Thank you all so much for coming. I am not going to stay tethered to that. I'm a wanderer, so I hope you're okay with me coming up and chatting as we go along. But thank you for coming to the People's Party tonight as opposed to the David Sedaris celebration down the street there. One of the benefits of being here is kind of like what Steve Martin said about Marty Short. He said, the best thing about you, Marty, is that we never have to worry about paparazzi. So there'll be no danger of paparazzi here tonight. I thought what I would do for those who haven't heard this before is talk a little bit about how the book came to be, and then get into a couple of the stories in the book. I'm thinking, and I want to make sure this is time well spent for you, so please tell me if you'd like me to go in a different direction. But I'm thinking, given what's going on in DC these days, that the chapters on voting rights may have the greatest salience. And so I thought I would spend a couple of minutes on two in particular that we'll get into in just a bit. All right, so how did the book come about? Well, as you heard in that very kind introduction that I wrote about myself, I am from Mobile and was educated in Mobile schools. I went to St. Mary's, go fighting Blue Jays, and then I graduated from McGill-Tulane in 1977 and went off to college, got a law degree, practiced law, some in Alabama, some in Washington, and at that point, my wife and I, who were living up in DC at the time, decided to change everything about our lives pretty much. We were at one of these overpriced restaurants in Washington, DC, having the kind of conversation that married couples have, you know, how are things going? You happy with your work? And so on and so forth. I had just gotten a new portfolio of work dumped on me that I wasn't thrilled about, but I said to Linda, you know, I'm still not loving that. I was with the American Bankers Association at the time, having been a banking lawyer for a bunch of years. I said, I'm not loving it, but you know, I think I'm just gonna keep plowing ahead. And she said, she doesn't like it when I tell the story, but she said, bullshit. Do what you wanna do. And when I say it today, I have the reaction of, well, of course. Of course, why wouldn't I want to do what I want to do? But it was so liberating for Linda, my wife, to say that. It really gave me a license to think about what is it that I've always wanted to do when I wasn't practicing law. And I said, you know, I was with the Federal Reserve Board for a while, Department of Treasury, finished my career in law at the American Bankers Association. Not the most scintillating stuff in the world. And a little lacking in the making the world a better place points as well. So as I was thinking about what is it that I've always wanted to do, I came back to teaching because Linda and I have two sons. Periodically we'd go to their back to school nights and I would see their teachers and they were just so happy. I mean, they were just loving life, radiating happiness. In fact, one of the people I went to law school with at Vanderbilt, who finished #2 in the class, she was a smart girl, law review and all that, was teaching 4th grade in Vienna, Virginia, where we were living. And she was just so happy. And I thought, I got to get me some of that. That's what I want. And so when Linda gave me a license to do what I wanted to do, I decided what I wanted to do was to teach. And so not only did we uproot careers, we uprooted where we were living, or in the DC suburbs at the time, and came back to Mobile. And as luck would have it, my alma mater, McGill-Tulane, needed a government teacher. And they made the terrible mistake of assuming, since I worked at the Federal Reserve Board, I also knew something about economics, and so they had me teach econ as well. But I taught econ and government to the esteemed Buddy Ahrensberg, among others. Buddy's a former student of mine. And did that for 12 years. And pretty soon after I started teaching, particularly the AP government classes that I was teaching, I kept coming up against all these cases that really fundamentally changed freedom rights in America. Often in the context of voting rights, but also in the First Amendment, public accommodation, public education, and so on. And so many of these were from Alabama. And I didn't know any of these things. I was born in Mobile, went to school up through 12th grade in Mobile, practiced law in Alabama for part of my career, and I just didn't know any of these things. And so I went to the administration and said, I'd really like to put a course together that is based around these cases that I kept coming up against. And that happened to be around the time of George Floyd and Black Lives Matter, and the emphasis on issues like that. And in fact, McGill had been taken to task by some of our former students, some of whom I taught actually, who wrote the president of the school saying, how is it that I graduated from McGill-Tulane and I never heard about systemic racism or a lot of other things that were in the news at the time. And I think my going to the administration with a request to put together this course was a happy coincidence for the administration because it allowed them to have something to say in response. Well, we hear you, we're going to put together this course. And so I did, and I taught it, and it had a clunky name originally. It was something like Alabama in the Supreme Court, famous civil rights cases, or something like that. But I wanted to emphasize Alabama history and the Supreme Court more than civil rights because I felt like that'd be better received by not just the student body, but their parents, to be perfectly candid. And so I taught that for a couple of years. Then Linda and I decided to uproot again, and we retired about 3 years ago. We came up to Huntsville to be near our oldest son, who was on the faculty at UAH at the time. And I had this body of work that I'd put a lot of time and effort into that I thought was important that people understand, particularly Alabamians, but really all Americans, because it really affects us all. And I offered it to my colleagues on the faculty at McGill, no takers there, which I understand. I mean, they all had full plates. I offered it to some colleagues that I had met along the way, and a lot of enthusiastic, yeah, that sounds great, we'll get back to you sort of thing. Nothing. And I was kind of sorry to see this body of work languish, and Linda, with the second epiphany she gave me, said, well, why don't you write a book? And, yeah, of course, I'll write a book, more blinding clarity. And so that's how the book came to be. Before I get into some of the tales about the book, let me set the table a little bit by talking about the title, because the title is a little incendiary, State of Segregation. It can suggest that my starting point is I hate Alabama, and I don't. Alabama, I love Alabama. It's done a lot of great things. It's done a lot of horrible things, to be sure. Find me a state that hasn't. And so I hope people aren't misled by the title, the State of Segregation. I went with that after my first submission to the publisher was rejected, and that was 50 Shades of Segregation, and they said, no, that's not going to no, I'm kidding. But what I tried to do with this is to communicate the big picture that the rights that we all enjoy were very hard fought, hard won, and very fragile. And if we're not careful, not only did we live in a state of segregation, a state that was in fact segregated, we may revert back to a state of segregation. And I think we're seeing a lot of that in some of the current administration's policies, quite frankly. All right, so what's in the book? Well, it starts with an introduction about this period of time following the Civil War called Reconstruction. Reconstruction is that time from about 1865 to 1878 with the election of Rutherford B. Hayes. I'll spare you the back and forth, but it was a time of real promise and real progress for the formerly enslaved. You have what are called the Reconstruction Amendments, the 13th, 14th, and 15th. 13th says no slavery. 14th does a whole bunch of things, including guaranteeing our equal protection under the law and due process, as well as granting birthright citizenship to anybody born on American soil. And then the 15th says you can't deny anybody the right to vote on account of race or condition of prior servitude. Huge deals, huge deals. The 14th Amendment is so important, it is frequently referred to as the Second Constitution. A lot of our basic rights that we unfortunately often take for granted stem from the 14th Amendment. And as you see in the book, if you have a chance to read it, most of these cases deal with either the Equal Protection Clause or the Due Process Clause. But Reconstruction bumps along for about 12 years. Blacks gain the right to vote. Blacks exercise the right to vote, and a lot of black politicians are elected. South Carolina was majority minority. It was a majority black state. And they elected a lot of politicians, both at the state level and at the federal level. With the election of Rutherford B. Hayes and his race against Samuel Tilden, you may recall from your history lessons, there was a dispute about electoral slates. Sound familiar? Hayes goes to three southern states and says, if you cast your ballots for me, even though you ordinarily would not, I promise to basically end the occupation of the South, and the South can get about dealing with the Negro problem as the South saw fit. Well, that was music to the ears of the people who used to rule the South and who were desperate to regain their stature. And Hayes delivered on his promise. So after Reconstruction, we enter into a period called the Great Redemption, a misnomer if ever there was one. It was a great redemption from the years of Negro misrule, as the white supremacists would say at the time. The Supreme Court during the Great Redemption essentially gutted the protections that the formerly enslaved thought they had won in the 13th, 14th, and 15th Amendments, as well as in several of the statutes that the Reconstruction Congress passed. Won't go into those here. I talk about them briefly in the book. But going into about 1900, the civil rights protections that were won, that were to be expected, you would think, coming out of the Civil War, a war to end the state's rights to have one individual own another, all of those were knocked down one at a time. Which gets us to the first case that I talk about from Alabama in the book. It's a case called Giles versus Harris. Jackson Giles was a black man. He was a postal worker with I'm not sure what I'm doing to squeak so much. But he was a postal worker, which was relevant because that gave him a layer of protection that a lot of blacks didn't have. If blacks tried to register to vote, there's a real good chance, at a minimum, they would be fired, and quite possibly beaten up and perhaps even lynched. Jackson Giles wasn't immune from the violence and intimidation, but he was immune from the economic retribution. And he had voted during this period of time following the Civil War. He voted several times. In 1901, Alabama convenes a constitutional convention. And a fellow named Andrew Knox from Anniston chaired the convention. And he begins by saying, and I'm going to try to quote it from memory, I may get a little bit wrong, but he said, "And what is it that we are here to do? Why? It is to preserve white supremacy within the bounds of the Constitution. He goes on to say, what we have done up till now was necessary in order to restore white supremacy, but it wasn't right. We need to do this the right way, which, the fact that his objective was to disenfranchise black people suggests that maybe he didn't have the right way in mind. But in the Alabama Constitution, they changed the law to require, among other things, that black people get white people to attest to their character. Whites didn't have to get anybody to attest to their character, but blacks did. Jackson Giles said, I'm not going to do that. I voted for years. There hasn't been a problem. I'm not going to play by those rules. He was denied the right to vote. He files a lawsuit arguing that it was a denial of equal protection. Again, whites weren't asked to get character references, and a violation of the 15th Amendment, which says you can't deny somebody the right to vote on account of race. The only people who were being denied the right to vote here were blacks. Seemed like a pretty clear-cut case of a violation of both the 14th and 15th Amendments. Of course he loses at the state level because you had a bunch of Alabama white supremacists on the court. But because he raised a federal question, i.e. was this law constitutional, it was appealable up to the United States Supreme Court, and up it went. There, the esteemed Oliver Wendell Holmes writes an opinion that is not nearly as well known as Dred Scott or Plessy versus Ferguson, but was every bit as damaging to blacks. Because what Holmes said was, Mr. Giles, you're asking us to add your name to the voter rolls. Well, aren't you, in so doing, making us a conspirator to fraud? I mean, you're saying the system is so fraudulent and so inequitable and wrong. Well, gosh, if we make you a part of the voter rolls, then we're complicit, and we can't do that. Then he says, your solution to this political problem is to go back to the politicians in Alabama and get them to change the law. You see the problem. I mean, the politicians were the problem. They're not going to fix it. People don't give up power willingly, and Alabama politicians certainly did not. So Giles versus Harris, handed down in 1901, made it possible for Alabama and every other state that wanted to disenfranchise blacks for 60 years. They were getting away with this nonsense. It wasn't until the Voting Rights Act of 1965, which is probably, it's an interesting parlor game among civil rights nerds like me, which statute was the most consequential. This is certainly one of the top two, this and the Civil Rights Act of 1964. But the Voting Rights Act of 1965 said a bunch of really good things. It said, first of all, don't discriminate on the basis of race. Just stop, okay? That's illegal. But it also said, if you are one of the states that had a particularly bad record of discriminating, and spoiler alert, Alabama was, then you had to get pre-clearance, prior approval, by either the U.S. Attorney General's office or by the district court for the Circuit Court for the District of Columbia. That was a stroke of genius, because not only did Congress figure out how to outlaw the known evils, they figured out how to make it possible to stop the unknown in advance by forcing the states to get pre-clearance. Alabama, from 1965 until 2013, had over 100 proposed changes to its electoral laws rejected or modified at least. And those were the ones they submitted. Those were the ones they thought had a chance. God only knows how many laws they would have passed if they had been free to disenfranchise people as they chose to. So it was a very effective law. A year after the Voting Rights Act goes into effect, Alabama went from around 90,000 registered blacks to a little over 220,000, just in Alabama in 1 year. Enormously consequential. Well, this gets us to one of the worst decisions, certainly in the 21st century from my perspective. Others can disagree on this, of course. It was out of Shelby County. You have a case filed by Shelby County. The case is styled Shelby County versus Holder, who was Obama's Attorney General at the time. And Shelby County was only the then most recent in a long line of plaintiffs trying to get the pre-clearance requirement overturned. This was the fourth time now that someone had tried to persuade the Supreme Court to overturn the pre-clearance requirement. And time after time, the Supreme Court said no, this was a properly authorized and executed bill. That in 2006, the last time it was reauthorized, it cleared the House with the approval of all but 33 of the 465 representatives. It cleared the Senate unanimously. I mean, it was a popular bill. The 2006 reauthorization was made after compiling a record of over 15,000 pages of ongoing discrimination, despite the Voting Rights Act. So, I mean, Congress actually did its job. And the Voting Rights Act was reauthorized for a fourth time in 2006. Well, Shelby County wanted to take one more swing at it. And they had an ace up their sleeve in the form of John Roberts. John Roberts, of course, is now the United States Chief Justice on the Supreme Court. He was a young lawyer working in the Justice Department at the time. Excuse me, actually he was on the bench. But when he was a young lawyer, he worked in the Justice Department, and he worked hard to gut key provisions of the Voting Rights Act, which we'll talk more about in a bit. But Roberts was now Chief Justice. Shelby County thought, okay, now's the time to go back up for the fourth time. And Roberts delivers. He says, 2013, which was when the case was decided, is not 1965. True. Sure, we did not have overt discrimination, denying blacks the right to vote, denying blacks even the right to register. Yeah, we'd gotten rid of that nonsense. So the Chief Justice was absolutely correct. But he completely glossed over the 15,000-page record compiled by Congress leading up to the fourth reauthorization, saying, well, you know, essentially reasonable people can differ on what the record means. Oh? Every senator didn't have a different point of view. They all agreed this was a bad thing. But he says, because times have changed, Congress has to do one of two things if they want to keep the preclearance. They either have to make a record specifically about the states that were subject to this requirement, and the 15,000-page record was more generic. It was about the nation as a whole. Or if Congress didn't want to do that and keep the preclearance limited to a few states, then they had to apply it to every state. Well, Congress wasn't going to do that. And so, thanks to Shelby County versus Holder, a key part of probably the most impactful civil rights statute was gutted, that preclearance requirement. The day after Shelby County was handed down, Alabama breathed life into a law that it had passed before the holding, but didn't even submit it for preclearance because they knew it wouldn't get passed. And that was a tougher voter ID law. The next day, it goes into effect. Estimates vary on how many people are disenfranchised and which group is most hard hit. There's a consensus that blacks were disproportionately disenfranchised by this voter requirement. It has since softened a bit. Alabama has moved closer to something approaching a reasonable approach to state-issued IDs, but it sure smacked of kind of the old South, getting rid of the undesirable votes because they were a threat to the power. I think this is the problem. I think it's my wife, maybe. I'm going to stay on over here. All right. Ruth Bader Ginsburg, appropriate for today, in fact, had the perfect response to Justice Roberts' opinion. She said, look, throwing away the pre-clearance requirement because there isn't discrimination is like throwing away your umbrella in a rainstorm. True, you're not getting wet in the rainstorm, but it's because of the umbrella. True, there weren't the horrific types of blatant discrimination that we had seen prior to 1965 because of the Voting Rights Act, because of the pre-clearance requirement. You get rid of that, and guess what you're going to see? A lot of discrimination. And guess what we have seen? A lot of discrimination. Which leads me to the second case I'm going to talk about, and then I'm going to turn it over to y'all to see what's on your mind. The other part of the Voting Rights Act that has been a lot in the news of late is Section 2 of the Voting Rights Act. It is a provision that said initially pretty much what the 15th Amendment said. Don't discriminate on the basis of race. Fair enough. A case out of Mobile called Bolden versus Mobile challenged the form of the city government at the time. Mobile used to be, when I was growing up, and several people in this room were in Mobile, Mobile used to have a 3-member city commission, and each commissioner was elected citywide. It's what's called an at-large election, and one of the 3 would rotate as kind of a ceremonial mayor, but they would all have separate responsibilities within their role as a commissioner. Well, Wiley Bolden, who was another one of these civil rights warriors, a black man, along with Burton LaFleur, who, a name you may probably have heard, LaFleur High School is named after him, filed a lawsuit.
Right under the speaker.
Yeah, okay. They filed, all right, it's really boogieing my pacing, man. I got to pace. I want to stand right there now more than ever. So they filed a lawsuit saying, look, Mobile is 2/3 white, 1/3 black then. It's pretty close to 50-50 now. We were 2/3 white, 1/3 black back then. In a citywide election, a black man's never going to be elected. Because all you have to do to get elected is win 50% plus 1 of the vote, get a majority. And whites voted for white candidates, just as blacks voted for black candidates. So they filed a lawsuit arguing voter dilution. It wasn't that they were denied the right to vote. They could register and turn out to vote and all that. But their vote just was diluted to the point of being useless. So they filed a lawsuit. It goes up to the United States Supreme Court, and there was some precedent in their favor. A case out of Texas called White versus Register. Ruled on facts that were analogous, not on all fours necessarily, but close enough. Ruled that, yeah, if you're lacked a meaningful opportunity to participate in the electoral process, in other words, if you can't elect the candidate of your choice, then you don't have the protections of the Voting Rights Act. So Bolden thought he had a pretty good case. Won at the appellate level, it goes up to the Supreme Court, and at that point, William Rehnquist is Chief Justice. William Rehnquist, he's long since met his maker, but he was a clerk to Justice Robert Jackson. If you're a fan of Nuremberg history, you might have known that name. Justice Robert Jackson, among his many accolades, was probably the finest writer of any Supreme Court justice that's ever been. Brilliant man, good justice. Well, Rehnquist clerked for Jackson, and while a clerk, wrote a memorandum in which Rehnquist said, I know this isn't going to make me popular among the other law clerks, the people right out of law school working for the Supreme Court, but I think Plessy versus Ferguson was rightly decided. Plessy, you may recall, was the case that said separate but equal facilities are okay. That's not violating the Equal Protection Clause of the 14th Amendment. So Rehnquist in the late 1950s was saying, I think segregation's okay. It's not unconstitutional. I think, again, I'm Rehnquist, I think Brown versus Board of Education was wrongly decided. Brown was the case that said separate but equal public schools are unconstitutional. So that gives you a sense of where Rehnquist is coming from. Rehnquist gathers the court together and persuades a majority of them to come up with a new requirement, not in the statute, but it's a new requirement that they just gloss on to the language, which is, if you want to prove a Section 2 violation, you have to show not just that the effect of a law was to discriminate, but that it was the intent of the legislatures to discriminate. In other words, you have to find a smoking gun, an email, a memorandum, something that says, we're really going to screw the blacks this time with this process. Well, as was pointed out at trial and before the Supreme Court, you probably weren't going to find that smoking gun because the law that gave Mobile its then current form of government was passed in 1911, 10 years after the Constitution of 1901. The Constitution of 1901 was so effective in disenfranchising people, blacks in particular, there wouldn't need to be the belt and suspenders in 1911 that said, okay, here's how we're going to disenfranchise blacks. And so, before the Supreme Court, Rehnquist, Bolden loses. Even though there was not a chance in hell a black man was going to be elected counselor, he loses because he didn't have a smoking gun. The case was remanded, sent back down to the federal district court. Virgil Pittman was the federal district judge at the time, for further proceedings consistent with the holding in this case, that sort of language. Well, on remand, a smoking gun was found. Someone actually unearthed a memorandum that explained in no uncertain terms what this change in 1911 was about, and it was about disenfranchising blacks. So Virgil Pittman says, you want proof? There's your proof. You want intent? There's the intent. And Mobile at that point folded its cards and said, okay, you got us. And that's when they changed to the current form of, I think we have 7 districts now, and we have a mayor that's elected citywide, and then 7 different districts, each of which are single-member districts. So districts that are comprising primarily black neighborhoods are going to have the chance to elect black candidates. It's not that, you have to have a black person representing blacks to do a good job, but blacks historically have tended to favor black candidates. Whites have tended, majority, to support white candidates for whatever reason. So, Bolden eventually wins his lawsuit, but he won something a lot more important. The national outcry to the case, to Rehnquist's opinion, was so severe. New York Times published an editorial saying this is the biggest setback for civil rights since the Civil Rights Act was passed. Others piled scorn on top of scorn. It was so severe that Congress actually got in the action and said, okay, we're going to fix this. We're going to change Section 2 to deal with this gloss of intent. We're going to say explicitly in the statute, as long as a law has the effect of discriminating on the basis of race, then that's unconstitutional. It's in the statute, Section 2B. It's in there today. Hey, guys. So, not only did Bolden ultimately win his individual lawsuit, he won something key for the nation as a whole, this effect standard that is in Section 2. Now, there was a lot of back and forth about, well, does this mean that blacks are guaranteed proportional representation, i.e. there are 30% blacks in Mobile, they get 30% of the politicians? No. That also was added to Section 2B as part of the compromise. Bob Dole, a long since dead politician from Kansas, brokered a deal where once they added the effects test, they also added this explicit caveat that this is not guaranteeing any group proportional representation. And so we rock along for decades with that change until about a month ago. And this case, the case that really was the domino that started the mess that Alabama is in today, was a case out of Louisiana called Calais versus Louisiana. Justice Alito wrote that, well, in order to bring a Section 2 case, the plaintiff, the person complaining that they're not able to elect a candidate of choice, has to show that nothing else possibly could explain why boundaries were drawn the way they were, congressional boundaries, other than race. If there's any other possible explanation, then it doesn't matter if the boundaries, in fact, discriminate on the basis of race. There historically has been significant overlap between blacks and Democrats. I'm not telling you anything you don't know. So now, all Alabama has to do, and did do in the Allen versus Milligan case, I'll get to that in just a second, is say, okay, man, she messes up my microphone, she's giving me the hook. Anyway, the party in power has to say is, we are drawing political boundaries solely for the purpose of helping a party. That's all they have to say. And that immunizes them, for all intents and purposes, from a challenge of racial discrimination based on the effects test. Alito, presumably with a straight face, said, we're not changing the effects test, it's still in there. But it's gone, it's gutted. There's nothing left to it as a practical matter. Allen, the case in Alabama, was one of the first cases, I think it may have been the first case after Calais, and again, we're talking real recent history, matter of weeks, where the Supreme Court had an opportunity to apply its new standard that allegedly hadn't been changed, but in reality had been gutted. Briefly, just to bring people up to speed on Allen, you had 3 different lawsuits that were combined under the name of Allen versus Milligan, where blacks were saying the effect of the way congressional boundaries were drawn is to make it impossible for blacks in some parts of Alabama to elect their candidate of choice. The district court, with 2 out of their 3 judges appointed by none other than Donald J. Trump, agreed. They said, yeah, these districts were intentionally discriminating against blacks. The federal district court made that finding in a 532-page opinion. Extensive documentation of ways the Alabama legislature discriminated against blacks. Goes up to the Supreme Court, and the Supreme Court, invoking something called the Purcell principle from a lawsuit involving a party named Purcell, said, oh, well, you know, this is too close to an election. This was not back in 2022. It's too close to the election. Alabama needs to be able to use the districts that they had drawn up, but then they can revisit this issue. So 2022 election comes and goes. Challenge was filed after that again, goes up to the Supreme Court on the merits. The Supreme Court said, yeah, you know, The federal district court got it right. There was intentional discrimination. The districts are unconstitutional. They have the effect of denying blacks the right to elect their candidates of choice. Alabama, you need to come up with 2 minority-majority districts. And so instead of having 6 white Republican and 1 black Democrat, currently we have 5 white Republicans and 2 black Democrats. Shamari Figures was the beneficiary of that decision. Well, maybe the day, but certainly the week after the Colley decision was handed down, Alabama petitions the Supreme Court for something called a vacator, a relief from their previous order saying you can't use the district that you want. The United States Supreme Court grants that and says have a new hearing on this. Goes back to the federal district court, again, 2 Trump appointees, not known for being liberals. Again, 3 weeks ago, they say yes. We've reviewed the record again, nothing's changed. The legislature intentionally discriminated on the basis of race. Alabama cannot use the districts that they want to use. Goes up to the Supreme Court immediately. The Supreme Court says, well, we think the district court just didn't appreciate what we had to say. They misinterpreted what we said. And so we are reversing the federal district court, and Alabama is now free to redraw their congressional boundaries however they think. Now, bear in mind the Purcell principle that the Supreme Court wrapped themselves in the flag of back in the earlier case was 4 months before an election. And in that case, the Supreme Court said, that's too close to an election. We don't want to interfere with the process, it'll be confusing and so on. In Allen, the election was already underway. Ballots were being received, mailed in, and the Supreme Court said, well, we don't think there's going to be any appreciable risk of confusion. Oh? Tell people in Mobile that, in the 4 congressional districts that went to the polls. Were y'all explicitly told that your vote wasn't going to count for U.S. congressional?
I think in Baldwin, it wasn't on the ballot. It will be on the August.
In August, okay, yeah. Well, now they're having to reconfigure the districts, get notices out to the people of where their new district is and their new precincts are and so on. I mean, it was enormously confusing to me, and I recognize I definitely bring a perspective to this. To me, it was blatant hypocrisy. It was the Supreme Court using this Purcell principle as a weapon to help Republicans in some cases and to hurt Democrats in others. I really don't like to talk like that because I have a lot of respect for all the Supreme Court justices. I think they're all very bright, and I think they're well intended, I really do. But I think one of the key differences between the holdings in the voting rights context of late, since the Warren Court, really, the early 1970s, one of the key differences is that Republicans on the bench seem to think that we are in a post-racial country, that race doesn't matter anymore. And therefore, protections that made sense back in 1965 aren't needed anymore, and they shouldn't be on the books. Others say, oh, post-racial? Let's look at the data on crime. Who gets arrested most frequently and gets the longest sentences? Who has the greatest net worth? Who has the worst health? Who has the lowest educational attainment? Et cetera, et cetera. I mean, demographic factor after demographic factor. Blacks come up short. For reasons that we could spend the rest of our lives debating, I'm sure. But to say that we are in a post-racial society, I think gives short shrift to a lot of the struggles that continue to go on today. All right, I will stop. Thank you all so much for coming. I appreciate your time and patience and your interest in the book.